In this last video of our three-part video series, we will discuss some more commonly made mistakes that some partners make when applying for UK partner visas. We will start with 3 online application form questions in particular that seems to cause some confusion. The first question that we will discuss is the question, what is your relationship status? So this question is asked early on in the application form, and it's asked for all partner visa applications, whether that's partner visa applications made from outside the UK or partner visa applications made from inside the UK. The drop-down box will give you 6 options. So those who are applying as a married or civil partner should, unsurprisingly, select married or a civil partner. Those who are applying as an unmarried partner and have lived together for at least 2 years should select unmarried partner. And finally, the commonly made mistake here is that those who are applying as a fiancé should select single, not unmarried partner. It's not completely intuitive to answer this way, I know, but it is the correct answer. Fiancés who select single here will be asked to confirm that they are applying as a fiancé in a later question in the online application form. A second thing that should be noted about the online application for those who are making an unmarried partner visa application from outside the UK relates to the question, are you intending to get married or enter a civil partnership in the UK? If you are wanting to apply as an unmarried partner and eventually intend to get married or enter into a civil partnership in the UK, we would advise that you state no. And this is because this question is with regards to the applicant's immediate intention, i.e. for the purpose of this application only. The third question that we felt that we had to address, just based on the many emails that we've received, is the question, have they, referring to the applicant or sponsor whose employment income you're relying on, been employed by the same employer for the last 6 months prior to the date of application? And the reason why we've been asked for clarification on this question as many times as we have is because if in the online application form you answer not the same amount continuously, it is likely that 12 months worth of documentation as opposed to 6 months worth of documentation will be requested. And the reason for this is because the online application form wrongly assumes that you want to apply under Category B in many cases as opposed to Category A. Whether the same amount has been received in the relevant 6-month period under Category A is not a determining factor as to whether you can apply under Category A or not. Therefore, the first point I'd like to emphasize here is that how you answer this question does not change the documentation that you are required to submit. As we touched on in the first video, the documentation that are required to be submitted is determined in accordance with the immigration rules, not the online application. Therefore, if the online application form states that you must provide a certain document, and even require you to confirm that you're providing this document, such a document is only mandatory if it is stated as being mandatory in the immigration rules. The second point here is that it does not really matter how you answer this question. You'll not be penalised for answering this differently to what the Home Office caseworker would. Again, your application will be determined in accordance with the immigration rules. With this being said, I know that it will give many of you better peace of mind if you do approach this in a way in which the Home Office caseworker is likely going to construe this question. So let's break down this ambiguously worded question. First, the same amount continuously above the financial requirement amount. You can select this if the person's employment income is the same throughout the 6 months, and the payments, when converted to a gross annual salary, is above the financial requirement amount. For more information about how to calculate the amount of employment income that you can include towards the financial requirement, feel free to watch our Spouse Visa UK Requirements and Process YouTube video. Typically, those in salaried employment who have not received any bonuses or overtime in the 6-month period select this. For example, if the person's total employment income throughout the relevant 6-month period was £2,500 each month, they would select this option. The same amount continuously below the financial requirement amount. This is relevant for those who have received the same employment income throughout the 6 months, and the payments, when converted to a gross annual salary, is lower than the financial requirement amount, which is obviously fine if the person's combining that employment income with another source of permitted income. For example, if the person's total employment income throughout the relevant 6-month period was £1,000 each month, which equates to gross annual income of £12,000, which is below the financial requirement amount, they would select this option. Not the same amount continuously above the financial requirement amount. This is relevant for those who have not received the same employment income throughout the 6 months, and the payments, when converted to a gross annual salary, is above the financial requirement amount. This would therefore include those in salaried employment who have received bonuses, overtime, or commission-based pay in the relevant 6-month period, as well as those in non-salaried employment whose income will naturally vary each week or month. For example, here we can see that the person's total employment income throughout the relevant 6-month period varied each month, whether that's due to working a different number of hours or due to a different amount of bonuses being received in certain months. We can also see that when you convert these figures into a gross annual salary, the financial requirement amount will be satisfied. And finally, the fourth option, not the same amount continuously below the financial requirement amount. This is relevant for those who have not received the same employment income throughout the 6 months, and the gross annual income calculation is lower than the financial requirement amount. As we discuss in our 1 hour plus long in-depth UK spouse visa requirements and process YouTube video, this calculation varies depending on whether the employment is salaried or non-salaried. The second commonly made mistake that we will discuss is with regards to the translation of documentation. There are 3 mistakes that partners can make regarding the translation of documents. 1. Not translating documents which must be translated. 2. Translating certain documents which do not need to be translated. And 3. Getting a translation done but not meeting the translation requirements. So what are the documents which must be translated? Firstly, specified documents must be translated if they are not in English or Welsh. The specified documents for partner visas can primarily be found in Appendix FMSE. If a document is specified, as in it's listed in Appendix FMSE, it is often the case that such a document will be mandatory. Specified documents therefore include not only the financial documentation, but also other documentation such as marriage certificates, if the applicant is applying as a married partner, and divorce certificates, if the applicant or sponsor have previously been married to another person. The second subheading that we have here is documents which may need to be translated, and under this heading we have listed non-specified documentation, that is, documentation that is not specifically listed as being mandatory in the immigration rules. So as much as I would love to be able to provide a definitive list stating the non-specified documentation and whether they should be translated or not, this ultimately will vary depending on the particular application in question. For example, where the sole parental responsibility requirement applies to one of our clients, and we'll discuss this requirement later on in this video, one documentation which is not listed in the immigration rules, but it will be helpful to obtain and submit, is often a letter from the child's school. If we're able to obtain certain legal court documentation which in effect states that the applicant is sole parental responsibility, we would often not advise that the letter from the child's school is translated, due to the unnecessary additional costs associated with getting a translation done. On the other hand, if the application is such where there is a risk of the sole parental responsibility requirement not being met, this is an instance where we would recommend for it to be translated. Another example is a joint tenancy agreement for unmarried partner visa applications. If the joint tenancy agreement is required in order to evidence 2 years cohabitation, we would normally recommend for it to be translated. On the other hand, if the applicant and sponsor are able to provide us with other evidence which will satisfy the 2 years cohabitation requirement, we would often not recommend for it to be translated. So hopefully from these 2 examples you get the idea that when it comes to non-specified or non-mandatory documentation, this really requires a question of judgment based on how important that document is to the application. So which documents should not be translated? If the document is irrelevant or carries no weight with regards to satisfying the requirements, we would not recommend for it to be translated, as doing so would just be a waste of money. General examples here include the applicant's and sponsor's birth certificates, which are not required nor are they relevant in the majority of applications, and letter from friends and family. If you do decide to translate documents, there are certain translation requirements that you must be aware of. The immigration rule states that the translation must include 1. The date of the translation, 2. Confirmation that the translation is an accurate translation of the document, 3. The full name and signature of the translator or an authorized official of the translation company, 4. The translator or translation company's contact details, and 5. If the applicant is applying for leave to remain or indefinite leave to remain, i.e. in-country applications, the certification by a qualified translator and details of the translator or translation company's credentials. It's also worth noting that if you need or want to translate certain documents, the immigration rules does not prohibit translation to be done overseas. These can be done by either a translation based in the UK or a translator based overseas. Finally, it's also worth noting that when you get a translation done, both the translation and a copy of the untranslated document should be submitted. The next mistake that we will discuss is not knowing when the applicant's income can be included towards the financial requirement. We will start with employment and self-employment income. The immigration rules say that the applicant's employment and self-employment income can be included if the applicant is in the UK aged 18 or over and working legally. Let's start with an in-country application example. As a reminder, in-country applications are applications that are made whilst the applicant is in the UK when the online application is submitted. Abby is already in the UK on a UK partner visa and wants to apply for a partner visa extension. UK partner visas permit both employment and self-employment in the UK, with the exception of UK fiancé visas. Therefore, Abby can include his employment and self-employment income towards the financial requirement. On the other hand, let's use the example of Lucy, who's residing in Canada, her home country, who does not have any UK visas and must therefore make an out-of-country application. Lucy earned an equivalent of £500,000 in employment income as a doctor. However, since she's not in the UK, Her employment income of £500,000 a year is completely irrelevant when it comes to the financial requirement. It cannot be included. Now, for whatever reason, we've seen that many partners assume that the previous provision extends to all other sources of income, which it does not. And because of this, many partners assume that all of the applicant's income is irrelevant, which it is not. So not including employment and self-employment income, what are the applicant's other sources of income that can be included towards the financial requirement? Firstly, the applicant's Category C income, which is often referred to as non-employment income, can be included towards the financial requirement. Category C income includes property rental income, dividend income that is not from a specified limited company, and income from investments, stocks and shares, bonds or trust funds, and the other sources listed here. The applicant's cash savings can be included towards the financial requirement under Category D, and finally, the applicant's pension income can be included towards the financial requirement under Category E. The next mistake that we will discuss is relying on prospective accommodation in order to satisfy the adequate accommodation requirement. Accommodation cannot be prospective. In other words, you must provide documentation prior to the visa being granted, which shows that there will be adequate accommodation for your family unit once the visa is granted. Now, for some partners, arranging the accommodation simply for the purpose of satisfying the adequate accommodation requirement is far from convenient, as it will often involve agreeing to a financial obligation, such as a 6-month lease, not only before the applicant enters the UK, but even before you know whether the applicant can enter or stay in the UK or not. Therefore, the question, what if we do not currently have any accommodation arranged, often arises. If the applicant or sponsor does not already own accommodation in the UK that can be relied on, the common solution here is to rely on a family or friend's accommodation, just for the purpose of the application. In other words, you can state in your application that you will be residing at a family or friend's house until you both find suitable alternative accommodation. There are several pros to this approach, such as 1. You will not have to tie yourselves down to a financial obligation. 2. There are often no additional costs associated with relying on a family or friend's accommodation. 3. A family or friend is likely going to be willing to help you by providing the required documentation. And 4. For those who are making an out-of-country application, this will allow both of you to view and decide properties in the UK which you would both happily live in. Now, if you do rely on a family or friend's accommodation, you'll have to ensure that it will not be overcrowded. Not being overcrowded essentially means that the accommodation has enough space for your family unit and the other cohabitants based on the number of rooms available as sleeping accommodation. More information about the overcrowding requirement can be found in Appendix FM 1.7 capital A. The second option, if the applicant or sponsor do not already own UK accommodation which can be relied on, is to rent accommodation. There are a few things to note about this. Firstly, the Home Office guidance does not state anything about a required minimum tenancy period. Rather, what matters is that there will be adequate accommodation for the family unit once the visa is granted. Secondly, for those making an application from outside the UK, a fairly common question is whether partners can rely on booking a hotel or an Airbnb. Whilst we've seen that some partners relying on an Airbnb or hotel accommodation have satisfied the Home Office caseworker that there will be adequate accommodation, this is not something that we generally advise in light of the significance and cost of the application, as not all Home Office caseworkers would agree that it will be suitable. And the third option that a minority of partners may decide to pursue is to buy a property prior to submitting the application. It should be noted, however, that in such a case, the conveyancing process has to be completed prior to submitting the documentation. This is because they'll be expected to provide legal documentation showing ownership of the property that's being relied on. The next mistake that we will discuss will be relevant to you if you decide to rely on cash savings to either satisfy the financial requirement alone, or use it in combination with another source of permitted income to satisfy the financial requirement. If you don't intend to rely on cash savings to satisfy the financial requirement, you probably want to skip this bit. The immigration rules states that the savings must be held in cash. And contrary to what some partners may think, equity, investments, stocks, shares, and bonds are technically not treated in the immigration rules as being cash savings. Let's use the example of Charlotte, who owns a home in the UK worth £200,000, has stocks worth £40,000, and has £30,000 in her personal bank account on the date that the online application is submitted. The amount of cash savings that can be included towards the financial requirement, in her instance, is £30,000. Charlotte's property and stocks, however, can be included in the immigration rules in limited circumstances if they're sold within the 6-month period under the 2 provisions which we will shortly discuss. So that is the position in the immigration rules. There are, however, 2 things that may be worth noting here. The first is that, despite the immigration rules stating that cash savings must be held in cash, NS&I premium bonds have long been treated as being cash savings by Home Office caseworkers. The second is in relation to stocks and shares in a UK stocks and shares ISA. Like the NS&I bonds, stocks and shares in a UK stocks and shares ISA are not permitted in the immigration rules, but it is nevertheless commonly accepted as cash savings by Home Office caseworkers. This is reflected in the Home Office Guidance, Appendix FM 1.7, which is not technically the immigration rules, where it specifically mentions stocks and shares in a UK ISA account as being permissible as cash savings if the cash value is clear. With this being said, we have seen a minority of Home Office caseworkers not treating NS&I bonds and stocks and shares in a UK ISA account as being cash savings. And it is because of this why partners, in order to err on the side of caution, may decide to sell these prior to submitting the application under a provision in the immigration rules which we'll discuss shortly. So there's a provision in the immigration rules which allows investments, stocks, shares, bonds, or trust funds to be included towards the financial requirement as long as, among other things, these are sold or transferred prior to submitting the online application. In such a case, if you sell these and then transfer the cash savings into another personal or savings account, you will not have to wait 6 months after the transaction. For example, Peter has no cash savings in his bank, but has an investment portfolio of £100,000 comprising of stocks and shares. He has held this investment portfolio for longer than 6 months. In order to satisfy the financial requirement via cash savings, Peter will need to sell the required amount of investments and receive the cash savings in his personal bank or savings account prior to submitting the online application. Peter will not need to wait until the cash savings from selling the investments has been in his account for 6 months. Rather, he can technically submit the application on the date that he receives the cash funds. In order to rely on the provision which allows him to rely on the cash savings resulting from the proceeds of the sale of stocks and shares, he will have to submit evidence showing that 1. The investments, stocks, shares, bonds or trust funds were in the ownership and under the control of the applicant, their partner, or both jointly, for that part of the 6-month period prior to the date of application before they were liquidated into cash savings. 2. The value of the investments, stocks, shares, bonds or trust funds at or before the beginning of that 6-month period was at least equivalent to the amount of cash savings relied upon in the application. And 3. The cash savings meet the other cash savings requirements. And secondly, there is a provision in the immigration rules which allows equity and property to be included towards the financial requirement, as long as, among other things, the property is sold prior to submitting the online application. This in effect means that if you sell a property which was owned for the 6-month period prior to submitting the online application, you will not have to wait 6 months until the cash proceeds has been sitting in a personal bank or savings account for 6 months. Rather, you'll be able to submit the application shortly after receiving the cash proceeds of the house sale. For example, Nancy has no cash savings but has a property which is owned for several years, worth £200,000 that she's intending to sell. At £200,000, the cash proceeds of the property will satisfy the minimum income threshold alone. Once the property is sold, she'll be able to submit the application shortly after receiving the cash proceeds, since the property was held throughout the 6-month period prior to submitting the online application prior to the completion of the sale. In order to rely on this provision, Nancy will have to provide evidence to show 1. That the property was owned by the applicant and or sponsor at the beginning of the 6 months prior to the date of application. 2. That the property was owned by the applicant and or sponsor at the date of sale. 3. The applicant and or sponsor's prior share of equity in the property. 4. That any mortgages or loans secured on the property have been repaid. And 5. That any taxes and professional fees associated with the sale have been paid. There are no additional mandatory documents here, but rather, the Home Office provide the following examples of evidence that can be submitted. Land registry information or documentation from its overseas equivalent if the property in question is located outside the UK, a letter from a solicitor or other relevant professional if the sale takes place overseas, instructed in the sale of the property confirming the sale price and other relevant information, a letter from a lender on its headed stationery regarding the repayment of a mortgage or loan secured on the property, and confirmation of payment of taxes or professional fees associated with the sale. So one suggested documentation that should have been included in the Home Office guidance for property sales in the UK is a completion statement which can be obtained from a solicitor as it contains much of the required information. The last mistake that we'll discuss in this video series is not satisfying the requirements for dependent children applications. This is largely because the requirements are poorly publicised on the internet, especially as they relate to the sole parental responsibility requirement, which we will discuss. The lack of Home Office guidance about dependent children applications, and by this we mean dependent children who are also applying at the same time as the main partner visa applicant, has resulted in much of the relevant information being found in academic textbooks and judgments from court cases. So I do hope that the following information is as clearly laid out as can reasonably be expected. The first thing to note here is that these requirements only apply to dependent children that are applying for a visa. For example, the applicant and sponsor have 2 children who also want to live and stay in the UK. One child is British and the other child is Thai. Since British citizens do not need to apply for any UK visas, the requirements only apply to the Thai child. Example 2. An Ecuadorian applicant has 1 child who only has Ecuadorian citizenship, and unlike the first example, the child is staying in Ecuador with the other parent, and therefore the dependent children requirements do not apply. Therefore, if you're not applying with any children, feel free to skip the rest of this video. If you have not already, I would recommend watching our spouse visa requirements and process YouTube video, as I'm very certain that it's by far the most comprehensive spouse and partner visa video guide on the internet. Okay, so let's go through the additional dependent children requirements. I use the word additional here because the dependent children application will require the child's parent to also satisfy the immigration rules if they're applying at the same time as their parent. The first requirement is that the dependent child must be under the age of 18 when the online application is submitted for their first application, or must have been under the age of 18 when the first application was submitted. For example, the applicant has one child who will be 17 when the online application for the first partner visa is submitted. And when the time comes to extend the application, the applicant will be approximately 20, which is also fine. The second and third requirements are that the dependent child must not be married or in a civil partnership and must not have formed an independent family unit. The fourth requirement is that the dependent child must not be leading an independent life. This essentially means that the dependent child must be living with their parent or parents, except where they are at boarding school, college or university as part of their full-time education, must not be employed full-time unless they're aged 18 years or over, is wholly or mainly dependent upon their parent or parents for financial support unless they are aged 18 years or over, and that the child is wholly or mainly dependent upon their parent or parents for emotional support. And lastly, only one of the following requirements needs to be met. 1. Both parents, i.e. the applicant and sponsor, must be in the UK. For example, the applicant is an Australian national in the UK on a UK spouse visa. The sponsor is in the UK and is a British national. The applicant and sponsor have a child together. Since both parents, the applicant and sponsor, are lawfully in the UK, this requirement is met. 2. One parent, the applicant, must be applying to enter the UK whilst the other parent, the sponsor, is in the UK or will be joining the applicant in the UK. For example, the applicant is an Australian national who wants to apply for a UK spouse visa. The sponsor is in the UK and is a British national. The applicant and sponsor have a child together. And since one partner is applying to enter the UK and the other partner is lawfully in the UK as a British national, this requirement is met. Third, if one parent is applying to enter the UK and the other parent is not in the UK, then the parent applying to enter the UK must be the sole surviving parent, or there are serious and compelling family or other considerations that make exclusion of the child to the UK undesirable, and suitable arrangements have been made for the child's care. So, serious and compelling family or other considerations that make exclusion of the child to the UK undesirable has an incredibly high standard and is a very complex area. A video on this alone can very easily exceed an hour alone, so we'll not discuss this here. What we will note, however, is that these circumstances should be exceptional in comparison with the ordinary circumstances of other children in their home country. It would not, for instance, be sufficient to only show that the child would be better off here by being able to attend a state school. Or, if one parent is applying to enter the UK and the other parent is not in the UK, then the parent applying to enter the UK must have sole responsibility for the child's upbringing. Okay, so let's discuss the sole parental responsibility requirement, as it is often the reason why some dependent children will not be able to apply for a visa as a dependent child of the main partner visa applicant. The first thing to note here is that sole responsibility is a legal definition. Ultimately, where there is not certain acceptable legal documentation which in essence declares sole responsibility, it will come down to the particular Home Office caseworker to decide, based on the application and supporting documents, whether there is sole parental responsibility or not. Getting an ex-partner to write a letter stating that the other parent has sole parental responsibility will not suffice alone. The Home Office guidance makes it clear that joint parental responsibility will not suffice. It states, sole parental responsibility means that one parent has abdicated or abandoned parental responsibility, and the remaining parent is exercising sole control in setting and providing the day-to-day direction for the child's welfare. And it also states that the phrase sole responsibility is intended to reflect a situation where parental responsibility of a child, to all intents and purposes, rests chiefly with one parent. Such a situation is in contrast to the ordinary family unit where responsibility for a child's upbringing is shared between the two parents, although not necessarily equally. Unfortunately, not only is this requirement applied quite strictly, it is also one of the most complicated areas in the immigration rules as they relate to UK partner visas. Whilst we've always made a point that many partners can process their own visa without the assistance of an immigration lawyer, as long as they are willing to spend the rather substantial amount of time to familiarise themselves with the immigration rules, this is particularly an area where partners would greatly benefit from professional immigration advice. So what are the factors that may be relevant when determining whether a parent has sole parental responsibility? Well, such factors may include Who has been entrusted with the day-to-day care and control of the child? Who provides, and in what proportion, the financial and emotional support for the child's care and upbringing? Who makes the important decisions about the child's upbringing, such as with whom the child lives, the choice of school and religious practices? Have there been any periods for which the parent has been separated from their child? And whether sole parental responsibility has been recognised by the relevant legal system. For example, our last client where sole parental responsibility was a requirement was a national from Tanzania. She wanted to apply for a UK partner visa and bring her child with her. The child's father, a Tanzanian national, was aware of his son but had very little involvement in the child's life. There was no written agreement between our client and her ex-partner, and they had no court documentation because they were not married. We were able to satisfy the sole responsibility requirement by evidencing 1. That our client was primarily responsible for the child's upbringing. Our client lived with the child and was the sole carer since very early on in the child's life. The other parent played no part in this, and he only saw the child once a year. We also evidenced that our client was solely responsible for the major decisions in the child's life. For instance, she would make all of the decisions regarding schooling and healthcare. The child's father had no say. Also, we made it clear that our client provided the child with the vast majority of financial and emotional support, whilst the child's father did not financially contribute. And finally, 4. That the other parent consented to the child coming to the UK. So that is the end of this video series. I hope you feel that it was worth your time, and if you have not already, you may want to watch our 1 hour plus incredibly in-depth spouse visa requirements and process YouTube video.